and creatives to understand and leverage IP for growth and sustainability. Esther is passionate about raising awareness among innovators and entrepreneurs on the value of protecting their brands and ideas. So thank you, Esther, for accepting this invitation, and I welcome you to start where you wish in offering this webinar.
Thank you so much, Eunice, for that elaborate introduction. I'll just mute my video because my network is a bit shaky. Thank you for the opportunity today, the Green and Digital Innovation Hub, courtesy of Clarice, who requested me to give a presentation on this topic, and I'm happy today to present on the same. But let me start sharing my screen. Are you able to see my screen? Are you able to see my screen?
Yes, we can. You can put it on share mode.
Okay. Okay, thank you so much. Before we begin, how many of you believe registering a business name is enough to protect your brand? I'd like to see from the chat. Just to make it more interactive. Because your brand is the face of your business and your competitors know it. Your customers trust your brand, but do you own it? Do you own it? So before we dive in, I'd like you to look around you right now. Is there something near you that might be protected through intellectual property? Because we are talking about trademarks, which is a branch of intellectual property. Okay, it's okay. So let me just continue.
Yeah, I can see one where I am right now.
Okay.
So it does not have that protected thing, but something tells me that it is protected. It is the name Hanan, tissue.
Yes, yes.
So I usually see after the name they write TR to mean trademark, but this one is not written.
Yes.
But something in my spirit tells me it should be protected, the Hanan brand.
Interesting, interesting. I was hoping to see many people write on the chat, perhaps the chair you're sitting on, perhaps the pen you're using to write, even the phone you're using. Does it have a name, like the brand name, the trademark? What distinguishes it from the other brand that you don't like? So without further ado, let me just dive into the today's topic. How to safeguard your brand with trademarks, a practical guide for Kenyan SMEs. So I thought it wise to, first of all, go back and before talking about branding or trademarks, let's know the origin. So what is intellectual property? Intellectual property refers to the creations of mind, everything from works of arts, inventions, computer programs, trademarks, and any other commercial signs. It can either be industrial property or copyright related rights, like what we want to talk about today. Trademarks are live from the industrial property bit of it. If you have anything to do with artistic works or authorship, you're looking at copyright and related rights. Now, intellectual property should be seen as property. In fact, the Constitution of Kenya, Article 40, supports this, that intellectual property, it promotes and protects the IP rights of the people of Kenya. IP means intellectual property. So intellectual property should be seen as any other property like your car, land, because it can be sold, it can be bought, it can be leased, it can be licensed, it can even be passed under a will. Yeah. So it's important to see that intellectual property is property. So looking at branding, what is branding and what does it help your company or your business? So branding allows a company to differentiate its products and services
Hi,
from the
Esther.
competition. Yes.
Sorry to cut you short. Your slides are not moving.
Oh, wow. Okay. Let's see. Are they moving now?
Yes, they are.
Okay. Branding allows a company to differentiate its products and services from the competition or from the competitors by creating a bond with its customers to create customer loyalty. It is the feel that customers have when they purchase your product. That is the branding bit of it. It is how you buy Coca-Cola and you feel after, consuming it. That is the branding bit of it. That is the bond that you have as a consumer with a particular brand or company such as Coca-Cola. So through branding, companies position themselves in the marketplace, and it makes it difficult for competitors to poach such customers, because it say that a satisfied customer may leave, but a loyal customer is more likely to stay. Have you ever gone into a supermarket and perhaps you're buying soap or detergents and you're more into maybe Omo or Sunlight? It's because of the loyalty that you have with that particular brand that you're not enticed to, proceed and purchase another product that has been introduced into the market. So branding is about how consumers view the company image. What are your advertising models? Are they good? For example, when you look at how Safaricom advertises, how Airtel advertises, how do you relate to that? Do your customers, as a brand, do your customer recognize you fast when you just enter? Or for example, you're going to the bus stop. Are you more inclined into enabled or super metro, the brand, how you resonate with it? So, and why does it matter? Kevin Lane Keller says that consumers are starved for time and over. Sorry, can I proceed? Hello.
Yes, please proceed. I've muted them, the participants that were unmute.
Okay. Sorry about that.
Yeah, no, sorry.
Kevin Lane Keller says that consumers are starved for time and overwhelmed by the choices available to them. They want strong brands that simplify their decision making and reduce their risks. You don't want to enter into a shopping mall or a supermarket and you're thinking, do I buy Nivea? Do I buy Nice and Lovely? Do I buy Garnier? You want the fact that when you enter the place, your mind is already fixed that this is the brand that I want. So branding gives your business a significant edge over competition or over your competitors. And therefore, as a brand or as a business, have the customer view your business as the only solution to their problem, such that when you go, I have had an experience where I want to purchase this particular brand of bread. So when when the brand is not available, I feel like I can't take any other. So that is how such that the brand has made me feel like they are the only solution to my problem, and I can't. That problem cannot be satisfied by any other brand. So a strong brand engenders feelings of trust, reliability, loyalty, empathy, responsiveness, and recognition in the customer's mind. So having talked about branding in the informal way, trademark now comes in as the legal protection of your brand. As I'd mentioned before, Article 40 of the Constitution of Kenya, Sub-Article 5, establishes and promotes intellectual property rights of the people of Kenya, whereby trademark is one of them. And another law that governs trademarks in Kenya is Cap 506 Trademarks Act of 2001 that defines a trademark as a mark, anything used to distinguish goods or services, including devices, brands, headings, label, tickets, names, signatures, letters, numerals, or a combination of that. And the period of protection for trademarks is 10 years, but it's renewable. So these are examples of trademarks in Kenya. You can have a look at them. Some of them are not,
Hi, Esther.
some of them, yeah?
Sorry to cut you short again. Your slides are still not moving. You're still at slide 2.
Wow.
Hello.
No, I don't know what the problem is.
Clarice, I think Esther can put the slides in presentation mode so that you don't have a problem with moving the slides.
Actually, they're
Just
on
go.
presentation mode.
Just go.
I just
No,
escaped
they are not.
now.
They are not in presentation mode.
At the moment, no, but now they are. Are they?
No.
They're not in the presentation mode.
Yes.
Okay. What about now?
Not yet.
Oh,
Are
from
you
my end,
able?
they actually are.
Okay. Are you able to scroll just the way they are?
Yes, I am.
Because we can see them moving right now. So I think maybe we could go ahead this way.
Okay, it's okay. I'm sorry about this. So these are some of the examples of trademarks that we have, both local marks and international marks, as you can see them. So it can either be a word, it can either be a logo, it can either be a letter, it can either be numerals, pictures, it can even be in the form of 3D. Okay. So most SMEs confuse. Most SMEs think that if they have a registered business, then they're good to go. But that is not the case. That is not the truth on the ground, because there are different entities that are mandated to do these registrations. So for trademarks, we have the Kenya Industrial Property Institute that does the registration. And for the business registration, we have the company's registry. And when you look at the difference, looking at the aspects from the business, the trade name or the business name, and the registrar of companies, trademarks from KIPI, and the purpose. Why are you registering your business? Because you want to be identified legally. But when you're registering your trademark, is because you're protecting your brand. And then the business name, it only covers the name only, but for the trademark, it covers the name, slogan, and any other identification mark that you have that distinguishes your products or your business from another. So the business registration gives you a right to use in Kenya. It only gives you a right to use it in Kenya, but trademark comes with more other rights, exclusive rights, rights that help you to prevent unauthorized persons from using your marks or from confusing your customers. And then under the protection and scope, the business name, you realize that you can have multiple similar business names. But for the trademark, it actually, when you register it, it prevents another person from registering the same mark that is already in use or registered in the register. So what is the function of a trademark? I'm looking at it from the company perspective and from the consumer perspective. So from the company perspective, the trademark allows your company to differentiate its products from its competitors. And from the consumer point of view, it ensures that your consumer or your customers are able to distinguish your products and ultimately develop a brand loyalty. What I was explaining before, that you become more inclined to a particular brand, that when you don't find the product that you're accustomed to, you're unable to purchase. Now, the value of trademark is actually underestimated, but when you look at the screen right now, the value of trademarks in 2025, the one that has the highest value from from the screen is Apple. 574.5 billion in US dollars. That is the value of Apple as a brand, followed by Microsoft, which has 461.1 billion in US dollars. These statistics are from as at January, the 1st of January 2025. So that is how your brand, which is protected using trademarks, is very powerful. Now, the practical aspect bit of it is that you select a trademark. Upon selecting a trademark, you do your search and then you proceed to protecting through registration. After registration, you use it and maintain the trademark. Where somebody tries to use your trademark, you enforce your trademark. So what can be protected as a trademark? For you to protect your trademark, what you have coined as a trademark, it has to be unique and not descriptive. For example, having a word like a sweet to describe sweets, or chairs to protect chairs, that is very descriptive. So it has to be peculiar. The mark has to be able to distinguish or to distinguish your goods or products or services from that of your competitor. The mark should not be deceptive or scandalous. Additionally, the mark that you're intending to protect should not be contrary to law or morality. Then also, it must not conflict with existing trademarks. Are you registering something that is already there or something that is going to confuse consumers? Trademark comes in to protect such proprietors from that. It is also important to note that trademark protection or intellectual property protection as a whole is territorial. For example, you coin a very nice mark, you register it in Tanzania, and you don't register it in Kenya. So you cannot, if you find someone using it in Kenya, you're unable to bring infringement claims to them because you did not file the trademark in Kenya, but you have a recourse in Tanzania, the national place where you registered. So it is important to know that it is territorial in nature. Additionally, you can also protect your trademark nationally, that is through KIPI, or regionally through ARIPO, which is the African Regional Intellectual Property Organization, or through Madrid system, which is administered by the International Bureau of WIPO. So what cannot be protected now that we have seen what can be protected? Generic words, e.g. chairs, for protecting chairs, descriptive terms, national flags and emblems, deceptive, scandalous marks, common cultural goods. Those ones cannot be protected. So how do you check if your brand name or logo is already taken? At this stage, you've already made up your mind and you want to proceed to protect your brand through trademarks. You'll visit KIPI through their website and do a search, which is not compulsory, but it's very important to avoid conflicts. in case there's already an existing mark. Then secondly, so after doing a search, then you review the NIS classification. So NIS classification, you classify your marks according to your business. Are you into clothing business? Are you into body products? So Kenya adopts the NIS classification 12th edition under section 22 of the trademark rules. So it is an international standard of classifying goods. For example, business services are under class 35, clothing business under class 25, educational business under class 41. So what are the required documents for trademark registration? So I have categorized this into the document, the purpose, and who needs it. So you can do a search, as mentioned earlier, and the search is optional, but as I've mentioned, it is important. After doing the search, then you have the application form. When you want to officially apply and protect your trademark, use TM2. And that one, every applicant needs it, whether you're an agent or you're applying on someone's behalf or you're applying on your own, you need a TM2 application form. Then there's also TM1 authorization form. That is if you're unable to apply on your own, but you need services of an agent or maybe an intellectual property practitioner or a trademark agent, then you have to, TM1 is important. Then you also need the clear logo or representation of the mark that you're intending to protect. You provide, and in this case, you provide images or symbols for registration, high resolution images. Everyone needs this. Then, as mentioned earlier, you also need to specify the classification. Are you doing goods? Class 1 to 34 is on goods. Class 35 to 45 is on services. So you also have to classify or specify the goods or services you protect. If you do not file under the correct class, trademark protects only the goods that you have, only the class that you have. Trademarks protect only the class that you have specified. So if you do not do a proper classification, it will be detrimental to you. And then, of course, you need a payment receipt, proof of payment to show that you have done the requisite as required. Okay, now enforcing registration process in Kenya. As mentioned, this is now that a summary of what I've been mentioning. You do a search, which is optional but very important. And then you do the application. Don't forget to classify your services or goods. And then when you have submitted your documents, KIPI will confirm whether you have formally complied. And if you have formally complied, they proceed to the substantive stage, whereby the trademark examiner will check whether your trademark satisfies the conditions required. Is it descriptive? Is it deceptive? Is it distinct enough to be a trademark? So if that is done and it proceeds to publication, 60 days. 60 days it's published in the Kenya Gazette, awaiting opposition. If there's anyone who has a query on it, and they do a notice to the registrar in writing. When there's no opposition, there's the issuance of certificate. And now you have your trademark, which lasts for 10 years, subject to renewal. The timeline for this process is about 6 to 9 months, but it also comes down to you as an applicant. How promptly are you providing the information required? Are you providing the correct information? If you're not, definitely the process will slow down. So what are the benefits of protection? When you protect your brand through trademarks, it builds customer trust and brand loyalty through credibility. Additionally, it enhances the market competitiveness that you have. You remain competitive in the market. And also, it increases business value and attractiveness. It is through your trademark when an investor comes and they realize and find that you have a trademark to that effect, they get attracted, and it brings in more collaboration. And further, the trademark is an asset. As mentioned before, we said it's intangible, yes, but it is property that can be traded. So if you have your trademark, what can you do with it? You can sell it. You can license it. And when you license it, you gain royalties subject to the agreement you have with a third party. You can also do franchising, which is also an aspect of licensing. And furthermore, when you have your trademark, it gives you that negotiating power in a boardroom when you're seeking for funds. And at the end of it all as well, you get exclusive rights as a trademark owner, which helps you prevent others from marketing products under your business name or your brand's name, preventing others who would like to confuse others using similar marks. So you can see that the benefits are quite many. This is just the schedule of fees that I uplifted from the Kipi website. And I wanted you to see that it's not all complex as it's always as it's always said. You can actually plan for it as an SME and protect your brand. You'll use a little amount at the moment, but in future you'll be protecting your business. So upon registration, you've gotten your certificate. Now it is important to use your mark, because when you fail to use your mark, under section 29, your mark might be removed from the register on grounds of non-use. And you don't want that, having built your brand from scratch. So use your brand, maintain your trademark. And maintaining your trademark here means after registering your trademark, you might be reluctant and forget 10 years pass and you forget that you're supposed to pay or renew again the trademark through, of course, paying the fees. So in this case, intellectual property managers come in. You can have, as a business, intellectual property managers who check through or who do audits on all sorts of intellectual property rights that your business might have, yet in your case, you didn't know that that is actually regarded as intellectual property, and they will be helping you to monitor when to maintain your intellectual property. So that is very important. And upon registration, again, use your mark as a business asset. If you have a particular color, maintain that color so that it gives the customers, the consumers, that trust and loyalty. While offering the your goods or services, still maintain the mark. When you keep changing your marks, it sort of confuses the consumers, and it also brings issues of trust and loyalty. For example, if you deal in goods or maybe clothwear, you affix the mark on the goods so that customers are accustomed to such marks. Even when you're doing importation or you're exporting your goods, for example, if you have registered your mark in another jurisdiction, use that particular mark so that customers really know that indeed this is the brand that we are used to. So upon application and registration, it is the responsibility of the trademark owner to identify infringement and decide on measures to take. You, as the owner of the brand, it is you to have the responsibility. Are you, for example, in a marketplace and you see a product that is strikingly similar to yours, that is confusing your consumers. It is at this point that you decide on the measures to take place, measures to take. And there are various ways you can do this. You can do a cease and desist letter to the alleged infringer. You can collaborate with authorities who are mandated to do the search and seizure order, such as authorities in the anti-counterfeit authority. Cooperate with customs authority also to prevent counterfeit trademark goods. And also you could decide to go arbitration way or mediation way, which is also very good because it helps to preserve business relationships. In fact, we learned that during such infringement, infringement, so when you decide to take mediation or arbitration as a measure, you're sort of inviting the infringing party to collaborate with you. For example, you realize that the infringer might have reached markets which you are unable to reach. You grant them license, and at the end of the day, they give you royalties, and the business continues. So litigation should always be the last resort, because at the end of the day, one party must lose, one party must win. But when you go through alternative dispute resolution mechanisms, you realize that relationships are built and more collaborations are seen. So that is what I prepared for you today. And thank you so much for your attention.
Wow, thank you so much, Esther, for that insightful presentation and guidance. And I already see a lot of hands raised up. Not really, some are clapping. So then I will hand over to Clarice to moderate the next section of question and answers.
Okay,
Clarice, are you okay with that? Okay.
Yes, thank you, Dr. Eunice, and thank you so much, Esther, for the wonderful presentation. I see we already have a hand up. I think we could start with that. Israel, you can unmute yourself and please ask your question. Israel? We can't hear you.
Maybe we could take another question.
Okay, you could also post your questions in the chat if you're unable to. Oh, I have unmuted you. Okay, we could take Linda's question meanwhile. Linda is asking, how much does the registration cost? Hi, Esther. Hi, Esther, can you hear me?
Hi, Clarice.
Oh, yes, I was just reading the questions in the comments. There's someone who asked, how much does the registration cost?
Okay.
And then Peter is asking, can you patent a word like karibu? And can you patent an idea?
All right. Thank you so much for the questions. I'll start with a question on how much it costs to register a trademark. I would say it depends because, okay, there are standard charges such as a preliminary search. You want to check whether that trademark is already in use or existing or in the register. There's an amount of 3,000 for that. Then application fee. When you check the KIPI website, there all those charges are there. But the reason why I'm saying it depends is because you might be in a business, but you have two classes of products you're dealing with. So how you register, the registration of one class differs from the other. So the amount you're going to use for registration is not a one size fits all, especially if you have more than one classes of the products you're dealing with. Yeah, so that's how I'll respond to that. And in response to, I hope I've responded well to the person. In response to Peter Kibe, can you patent a word like karibu? I'm sure you meant, can you trademark a word like karibu? Because patent is another type of industrial property that deals with inventions for solutions in the field, for problems in the field of technology. So can you patent an idea? Again, we have copyright that deals with protection of expressions of ideas and not ideas themselves. From the ideation stage, you have to put what you're thinking about in a fixed medium for you to begin and start thinking of how you're going to protect it. So you cannot protect an idea. It has to be an expression of that idea. You have a song ringing in your mind, you have to express it and protect it using copyright. You have a beautiful logo, you have a beautiful logo in your mind, you have to express it, you have to draw it down so that because one of the requirements, one of the documents you need for registration, for trademark registration, is that mark that you want to register. Yeah. Next.
Joseph is asking, is there an organization or agents that you could refer that help startups with patenting and trademark processes?
Okay, I'd respond that at Key State Advisory, we also do that. We also help startups with patenting and trademark processes, because we are in this program called Inventor Assistance Program, which is a WIPO program that does that. And we are also registered patent and trademark agents with KIPI. So feel free to reach out to us. And also, if you're closer to KIPI as well, I think it's in Wayaki Way, yes, you can also proceed, and I'm sure they'll help you with that. But we are of service to you. Thank you.
Linus, I see your hand is up. You can go ahead.
Okay. Thank you, Clarice. I'm in transit and my background might be a bit noisy, but please confirm if you can hear me.
Yes, we can hear you.
Okay. Thank you for this opportunity. I just wanted to ask a question that I had. Is it Esther mentioned that trademark search is optional, but it's very important. So my question is really that if I have a trademark, I have something that I want to trademark, how would I know that it's not in use if the search is optional? And another question would be, at what point does someone acquire common law rights where you can use a mark without necessarily going through the registration process? Those are my two questions, and I hope you are able to capture them clearly. Thank you.
Thank you, Linus, for your questions. It's just like when you want to register a business, but for the business, for the company's registry, you have to do a search. That's why I'm saying, in as much as it's indicated optional, but at the back of your mind, you know very well that you have to do it so that you confirm whether the trademark you have been using or the trademark that you want to register is not in use or is existing. And your second question was on
My second question was on common law rights, where maybe a company may have the rights to maybe a logo or something without necessarily doing the registration.
okay, for common law rights accrue with time in terms of continuous use. That is how common law arises. But the bottom line is when you compare trademarks that have accrued their reputation due to continuous use with those that have been registered, the ones that have been registered have an upper hand, especially when it comes to infringement. When it comes to infringement matters, you're able to take the infringer to court, unlike the common law rights. Because for the common law one, it's unregistered. You're just claiming ownership, or it's through passing off. But for the one that is registered through KIPI, it's officially registered. It has a statutory cap to it.
Okay, thanks. Yes, I think that's that explanation is sufficient. Thank you, and back to you, Gladys.
Jerry, I see your hand is up. You can go ahead.
Thank you so much, Clarice, Esther, and Dr. Eunice, Dr. Caroline, for organizing this wonderful webinar. My one question is about well-known marks. I've been asking this question, but I've not found an answer, satisfactory answer on it, because my argument has been that sometimes you can find a well-known marks within a county level. Let's say example of Kenya. If a mark is well known in Nairobi, those people who have not been to Nairobi may not know this well-known marks, which for Nairobians, it is well known to them. So if you tell somebody maybe in Kisumu or maybe outside Kenya that this is a well-known mark, it will not be well known to them, but then it is also provided that well-known people can have rights on well-known marks. So how do examiners engage that this is now a well-known mark so that it is uniform, that if one examiner maybe in Mombasa will give the same result that this is a well-known mark, or outside the country or outside Africa? That is my question. How is it being determined?
Okay, so for well-known marks, there's no single formula, but an examiner will look at the degree of knowledge, the recognition of that mark, as you're putting it, in Nairobi, and what is the extent and the geographical area of such use. How long has it been known? What about the extent of its promotions and advertisements so that it is widely known and used? And then over time, this is the most important bit, what value is the mark associated to? What is the value that that well-known mark has developed over time? So you're looking at the value that that mark has developed over time. You're looking at the extent of use, and you're also looking at the duration and the degree of knowledge, the reputation that this mark has built over time. That is how I would respond to it.
Thank you. Thank you.
Okay, there are more questions in the chat. Israel is asking what is the difference between a brand and a trademark in layman language, and is branding the same as patenting?
So branding is different from patenting, very different. Because for branding, it's the informal way of how consumers view your business. It's the feel that your consumers have for your business. But for patenting, you've come up with an invention, with a new idea that is a solution to a problem in the field of technology. For example, anything that can be patented, including maybe a process of making a solution or a product that comes out of that invention. For example, a vehicle, an engine that is used to move the vehicle, or a simple tool such as a nail clipper or what we call a nail cutter. It is a solution, and the problem it's solving is cutting nails, with one instant clip. So what else? What else? What else? Where is the other question, Gladys?
He also asked. Wait. He also asked. No, the comments are going too quick. Is branding the
Yeah,
same
I've seen
as
it.
patenting?
I've responded to that. I think the next question is the difference between a brand and a trademark
Yeah.
in layman, if I'm not wrong.
Yes,
So
yes.
I'll repeat again. Your brand is the image your business has, the reputation, and how consumers view it. How do they feel? How do they view it? That is for a layman's perspective. But the trademark now is the legal protection for your brand. It is statutorily based. You can have a business which has gained reputation for, let's say, over the years or 20 years. But if somebody decides to come up with a similar name and they feel that it is distinctive and they register it at Kipi, there's a difference, because you as the brand owner, you only registered the trade name. Let's say X. And then the other person saw that X is so distinctive, they went ahead to register it at Kipi. That's why I started by saying that there are two institutions here, the Companies Registry and the Kenya Industrial Property Institute. One deals with ensuring your business is legal in the country, and the other deals with ensures that that business that is legal is distinctive. So a trademark is protecting your brand through the law, which is the Trademark Act, Cap 506. I don't know whether that is understood.
I believe you can hear me right now.
Yes,
Yeah.
Israel, we can hear you.
Ah, nice. So just to like get what what Esther is saying is, like, the brand is for the image, like, but the trademark is for the, like, the legal protection for the brand. Is it not so?
Yeah.
Okay. So
Let me make it simpler again. The layman, let me just put it this way. You have the brand, the image, but you have nothing
yes,
to
like a logo.
show. You only have, no, I'm saying you have the brand, you have the image of your business. Say a logo,
Uh-huh.
or for example,
Yes.
KFC.
Yes.
It has built reputation over
Uh-huh.
time. It has a kind of style.
Mm-hmm.
And then
Yes.
this is how to trademark. You have nothing to show for it. The only thing you have to show is the registration certificate from the company's registry. But now
Yes.
for the trademark,
Yes.
what you show is a
Mhm.
document which is tradable, a trademark certificate that you have been given. And it is not only a certificate on paper, it is a property and
Yes.
it gives you exclusive rights to prevent other people from using that. I don't know whether that's clear enough.
Ah, okay, 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 okay.
So when you have a
And
brand and
and
you have nothing to show, so you can't trade with it. You can't trade with it. But when you have a trademark registered, you can
uh-huh,
proceed to a larger company and tell them, I have
uh-huh,
this. Can we collaborate? Okay, what do you have? I have an asset. What asset do you have? I have a trademark. Or, for example, if you're a pharmaceutical company, you have the name registered, for
uh-huh,
example, this, but you have also this medicine you've manufactured, say, for treating malaria. But that medicine, the formulation is a patent, but the name, for example, malaria quick, that is the trademark. So when you go to the negotiating table, you not only have Bliss as a name registered by the company's registry, but you have a trademark called malaria quick and a patent to it, which is that formulation. So I hope that's clearer.
yes, it's very much clear. In regards to like the trademark is your like your stamp. For
Yes,
like let's say a document.
yes.
Ah, okay. So where does like patent come in? Like in regards to now that flow from now me
No,
making
I was
a
just
brand.
explaining. I was just explaining
Uh-huh.
that these intellectual property rights, they do not work in isolation. For example,
Okay.
if you have that logo, you need to
Uh-huh.
add something to it. Having that logo
Yes.
on paper is the trademark, but you
Uh-huh.
need to advertise so that your logo or your brand is known. So you realize the advertising bit of it again.
Yeah.
You're bringing in your, perhaps you're
Mm-hmm.
advertising it on your website. You're bringing in
Mm-hmm.
issues of copyright. Those are now issues of copyright. So for the formulation
Okay.
bit of it, for example, pharmaceutical companies, they cannot sell their products without trademarks. You want to know
Mm-hmm.
what is this you're buying? Is it malaria quick? Is it
Mm-hmm.
Panadol? It has to have a name. So that is how
Ah,
patent comes in here. So I was just trying to explain so that it's understandable. Yeah, I hope that's right. Yeah. I
yes.
can also
Okay.
see. Is that okay, Israel?
Uh, y- yes, but then I would also want to ask on the on the patent space because I would like her maybe to give me like a flow on how I'm if let's say I have an idea and the patent.
Sorry.
Um, uh, my question is,
Yeah.
uh, okay, like with the branding I've understood, and with the like the trademark I've understood, and my space where like I feel there's a gap. Okay, not actually a gap, but then I want to understand is if let's say I have an idea and I want to do like everything from the branding and the trademark patent. Could you give me a flow?
You have an idea on which aspect of intellectual property? Is it on the literary work side or
Uh-huh.
is it in the industrial property side? You start from there. You have an
It's on.
idea in
Uh-huh.
the artistic side. For example, you have a song,
Uh-huh.
you have an idea of a song, you
Uh-huh.
express it down in a fixed
Uh-huh.
medium, and then you have your
Yes.
copyright, which automatically, you get it automatically. You don't have to register it. So long as it's original, and it's in a fixed medium. You have an idea in the industrial property side. That is where patent comes in. That is where trademark comes in. That is where industrial design comes in. You have an idea. There's nothing you have done beyond the idea. So what you need to
Yes.
do is now to implement it. You have an idea that when you mix A, B, and C, you come up with, or you extract something from this plant, then you get a formulation. You see, now you've moved from the
Yes.
idea to the actualization bit.
Yes.
You've realized that, yeah, it's an idea and you've gone to the actualization bit. You've been writing down notes and all that from, for example, you have lab notes. So those are your copyright.
Yes.
Those are also your
Yes.
trade secrets. So having come up with this idea of this formulation, you now have two parts to decide whether you want it to be known, meaning you want to patent it, or you want it to remain a trade
Yes.
secret that makes you competitive in your own way, so long as you ensure that it remains a trade secret. Because once it's out, then you have no value, and then there's no competitiveness, and then there's no secret. So is that foundation better?
Yes, it's better, but then I want to know the flow of now from the inception, like all the way to the patent, the branding, and the trademark, like that flow.
So you have to do one at a time. You have the idea, then you've
Okay.
written everything down, but you have everything. You have not published, because if you publish, then now it becomes prior art to your work,
Yes. Yes.
sort of self-plagiarism to your work. So after that, now then you proceed. You're ready. You proceed and do a provisional. You do a search. You do a patent search, and then you do a provisional filing when you're still preparing your other. Maybe you're going to the prototyping stage and stuff. So when you do the provisional filing, it's that you're telling the competitor or the prospective infringer that, look, I've already protected this, so you cannot pass this boundary. And then now you come and you prepare your documentation, your specification, your claims, which is the legal definition of what you're protecting. And
So
then,
which book
but
am
it
I
is
approaching?
important. It is important at the ideation stage to know whether what you're trying to patent or what you're thinking you're able to patent is patentable. Is it new? And the novelty is global. Is it new? Is it inventive? And is it useful? Is it in the field of technology? So if you have those three, then you have confidence to take your expressed idea to the patent office. Yes.
Okay. Okay.
Then, of course, after going through all those processes and you have a patent for this formulation, which you know treats this or helps in this, then you need to give it a name. And that is where trademark comes in. But you realize in the beginning you had the idea, you wrote down notes, that is your copyright. So you already, in the beginning, you have already, you've begun the process of two intellectual property rights. You have either your trade secret, which you're thinking of patenting, and automatic copyright for the lab notes that you've been having. And then at the end of the day, when you get your patent, now you need to give it a name, which is the trademark. That is how the trademark comes in. And have you come up also with a design that is original and that is aesthetic? So that is also another in intellectual property rights. So intellectual property rights is wide, and it's a topic that we can
Yeah.
discuss for the entire day. Yeah. Thank you. I hope that's clear now.
I would have to get your contact maybe some other time we communicate kindly, if it's possible,
That's
kindly.
all right. So let me also respond to Peter Kibe's question on. So essentially, you only trademark a logo.
I see his hand is
Peter?
up. Maybe he could
okay.
unmute and ask his question.
All right.
Well, thank you so much, Esther. My question was, so, just for clarity, so a trademark is a logo, or what else should you trademark? Is a logo or a picture of your product? And maybe just to get that clear. And again, because you can have two businesses that have the same name, but they are fundamentally different. You can have a hotel at the corner called Karibu Restaurant, and then there's another tour agency called Karibu Travel and Tours, and maybe another real estate called Karibu Real Estate. So I just wanted to get that clarity on what you should patent. Is it the logo or the name of the sorry, not patent, rather trademark? What can you trademark? Is it the logo or the name of the business? Thank you.
Thank you, Peter, for your question. And let me begin by saying it's not only logos that are protected by trademarks. As we began, we said you can protect a name, you can protect a logo, you can protect a slogan, you can protect letters. And I'll give you example. A name, we have Safaricom, we have Toyota. When you, a logo, Apple, an iPhone, it has the Apple logo. Yeah. When you have a slogan like just do it, or the KFC, it's a finger licking good. You have letters such as KTN, KBC, you have numbers such as 680 hotel, that is if it is registered. I'm just giving you examples of what can be trademarked. And then there's also this signature for Walt Disney, for those who love cartoons or the Walt Disney, even the signature. What about colors? Ringtones, the iPhone ringtone, the sound. So from that, you can see that there's just a lot that can be trademarked, not only the logo. I hope I've responded well to that. Other question about the multiple businesses that you have. If it's under one umbrella, you can decide to have maybe the word, you can have a combination of all these things that I've listed. You can have a combination of all these things that I've listed that can be trademarked. Yeah, for the multiple companies you have. Thank you.
I don't see any other hand that is up or any questions on the chat. So I'd like to say thank you to you, Esther, for your valuable insights today, and I'll give Dr. Eunice the floor so that she can give the closing remarks.
Hi, everyone. Thank you so much, Esther, for this great presentation and for taking our participants through trademarks and for addressing the various concerns or the questions that they had. I hope that this has been very insightful to all of us. And also just keep posted because we offer various webinars of this kind. And also when I look through the participants, I see Prof. Tom Ogada. If Tom Ogada, it doesn't have Prof, but I assume that might be Prof. Prof, could you like to say something?
Yeah, let me see if I can be able to say something. Are you able to hear me?
Yes.
Yes. Okay. Yeah, so about a couple of things. Very delighted to have followed the presentation and discussions for the last 1 hour. So the first is really to say big thank you, Esther. I know you have already been thanked, but to do so once more on behalf of the African Center for Technology Studies and the Green and Digital Innovation Hub. I think you've done a good job to provide very, very useful information, address questions, and even answer the difficult one, like the distinction between a brand and a trademark, which is normally a very big challenge for people to differentiate. So well done, and thanks very much for that. The second thing I would like to mention is that I was very delighted with the volume of questions that have been asked by the participants. And I really therefore want to take this opportunity to say a big thank you for the participants who joined today. We are delighted with your interest. We are delighted with your questions. And more importantly, it gives us the impression that, yes, it is important to organize these webinars because there is information gap that needs to be filled. And we are delighted that as African Center for Technology Studies, we want to do this. The third one, which is the last one, is that it is clear that this webinar is not enough to address all aspects of intellectual property. And we deliberately decided to organize for this webinar focusing on trademarks and brand and branding. And so we will still be then offering also specific themes around intellectual property. You'll be able, therefore, to hear more about how to protect industrial property. And then, of course, Esther tried as much as possible also to explain this, and more importantly, why it is very important to protect the same. We may want to also organize a webinar focusing specifically on industrial design. But it is also important to mention that in Kenya and other African countries, not only patent is important, but also utility models. And I think because the Green and Digital Innovation Hub will be dealing mainly with micro, small, and medium scale enterprises, I'm imagining that the bulk of your innovations are around really things that can be protected through utility models. So we'll also be exposing you to that. There is a lot of interest in the area of creative industry, creative economy, and all aspects of copyright. So we may also organize a special session for that. And I know we are dealing with entrepreneurs in the area of green and digital innovation, to which, to some extent, then in the digital sphere, quite a lot of interest on copyright, but also there are some very, very interesting things that SMEs are doing outside there that can also be protected through the same. So in brief, we will still continue engaging you. And today's was like appetizers. You should be able, therefore, to be alert as we organize more webinars so that you can be able to benefit from this. In the final analysis, our big interest is to ensure that Kenyan micro, small, and medium enterprises can be able to really harness intellectual property rights to develop their business. Actually, I should have also mentioned that we'll have a special webinar, how to make money out of your intellectual property assets. And that's commercialization and technology transfer. So quite a lot of interesting things in the, and we look forward to engaging with you. And don't feel tired to reach out whenever you have a problem or a challenge that you'd want to be addressed through our intellectual property unit that we recently established. Thank you, and back to you, Eunice, to close.
Thank you, Prof, for the remarks, and to all our participants. And Esther, thank you again. As you've heard, this is not the end, this is just the beginning. And so stay tuned. For the interest of time, I would like to end the webinar here. And bye-bye, see you again.
Eunice, maybe you can share your contacts.
Okay, let me share Peter before I leave.
And also Esther's contact details and the slides.
Yes.
Kindly.
Though Esther shared her email somewhere. Okay, I've shared both my email and my contact, which you're free to reach out. Let me see. Esther shared her email, which I'm still pasting back in the chat. And also the slides should be shared. Clarice, are you still in the meeting? Do you have the emails of all the participants? Okay, then.
Yes, I'm going to share the slides and the recording as well to all the participants that have joined us today. So look out to it.
Okay, then great. Bye, everyone, and see you again.
Thank you.
Okay, thank you.
Thank you, everyone.
Thank you so much. Thank you.